Hello, I'm Gupesh and you are watching Legal Bites. This is the third video in the Hindu Law series and the topic for our today's video is the concept of joint Hindu family and coparcenery under the Hindu law. The topics we shall be covering in this video are: what is a joint Hindu family, who is a common male ancestor, some characteristics of the joint Hindu family, what is a coparcenery and how is it created, 4-generation rule in coparcenery and a leading case law on 4-generation rule, a difference between joint Hindu family and coparcenery, the concept of survivorship, and at the end of the video there will be some important questions for pre and mains examination displayed on the screen. Let us begin our today's video. A joint Hindu family. A joint Hindu family, if understood in a very basic sense, it comprises of a large group of people in a family which includes both male and female. A joint Hindu family is a very basic and a fundamental unit under the Hindu jurisprudence. If understood in legal terms, it originates from a common male ancestor. Now let us see who all are the members of a joint Hindu family. A joint Hindu family consists of a common male ancestor along with his wife, his lineal male descendants up to any generation along with their wives or widows, unmarried daughters in the family, and children of the male descendant. The joint Hindu family is a sui generis concept to the Hindu law only. There is no such parallel concept in any other religion or school of thought. Also, joint Hindu family is a creation of law and cannot be created by a mutual agreement between the persons or partners. For example, if today I and Mr. X agrees to rent a house together for our mutual convenience and share our common expenses, this does not create or brings into existence a common joint Hindu family. Rather, it is an agreement for our mutual convenience. Because a joint Hindu family originates from a common male ancestor, and here we don't have a common male ancestor. Now let us understand the concept of common male ancestor and how a joint Hindu family comes into existence with the help of a diagram displayed on your screens. There is a person H who is a common male ancestor here, and below him is his family tree. Here his wife is W and they have 3 children S1, D, S2. S1 and S2 are the lineal male descendants of H. From S1, he has 2 children. S1S is a son, S1D a daughter through his wife S1W. And from S2, he has a son S2S from his wife S2W. And S2S further also have a son S2SS from his wife S2SW. Here, S1, S2, S1S, S2S, S2SS are the lineal male descendants of the common male ancestor H, and they have their wives W, S1W, S2W and S2SW. They have 2 unmarried daughters here in the family, D who is a daughter of common male ancestor H and S1D who is a daughter of S1. So all these people together constitute a joint Hindu family. Now we come to the characteristics of a joint Hindu family. We've just now seen that a joint Hindu family comes into existence through common male ancestor. But what would happen to the existence of a joint Hindu family if the common male ancestor dies? Would it cease to exist? No. It continues till perpetuity once it has come into existence. Once it has been started, it continues for the time immemorial unless a partition is proved in the family. For example, if there are only 2 widows left in a joint Hindu family, would we say that it has ceased to exist? No. They still have scope of addition of a new member to the family by way of adoption or by birth, thus carrying forward the name of the family further. Now we can see that there are 3 main ways by which a person acquires the membership of a joint Hindu family. The first one is by way of birth into the joint Hindu family. Second is by way of marriage to a male member. Third is by adoption into the joint Hindu family. A joint Hindu family is not a separate juristic person from its members. Therefore, it cannot sue and cannot be sued in its own name. Rather, it is the Karta. Karta is the head of the family who sues or can be sued on behalf of the joint Hindu family. A general presumption is that every family is joint family unless a partition is proved into it. We know that a family which is joined in food, shelter and religion is considered to be a joint Hindu family. But for some reasons or for any of the factors in life, the members of the joint Hindu family may be living separately at different places. For example, if one of the son of the family is living at Mumbai for work, the second one living at Delhi for studying, and the third one living at Dehradun for medical treatment. Does that mean the family has ceased to exist as a joint Hindu family? No, because unless they entertain an intention of separation, there remains to be a joint Hindu family. Now we come to the second part of our video, the concept of coparcenary under the Hindu law. To understand the concept of coparcenary in the simplest way, let us first understand who are the persons who can offer spiritual ministerial obligations, that is the pindadan, to their ancestors. That is, the persons who can offer pindas to their ancestor or forefathers are considered to be the part of a coparcenary. A coparcener has a birthright in the joint Hindu family property. Coparcenary is dealt within the Hindu Succession Act 1956, but it has undergone major amendments, that is, major changes after few amendments into it. Under the classical concept of coparcenary, only the male members were part of it, but after the 2005 amendment, now the daughters are also included under the coparcenary. To further understand the concept of coparcenary, let us see how a coparcenary is created. For this, we will be taking help of the diagrams displayed on your screens. F has his wife W and a son Fs. F had no property from his father, grandfather or great-grandfather. He earned a house by his own self-labor. Therefore, this house which belongs to him is his separate property. Fs got married to W1 and had a son FSS. After some time, F passed away. Now, the house which F owned, that was his separate property, devolves on Fs by way of interstate succession as provided under Section 8 of the Hindu Succession Act 1956. But with respect to FSS, this house which Fs now holds has a character of ancestral property. As we popularly say in Hindi, Dadalai Sampatti. For FSS, it is a Dadalai Sampatti. So, from now, Fs and FSS constitutes a coparcenary in relation to that ancestral property, that is the house. From now, a coparcenary is created. As we've seen how a coparcenary is created, now let us see up till what generations people are included in the coparcenary. In a coparcenary, the 4 generations rule is preferred. That is, people starting from the last maid holder within the next 4 generations are included in a coparcenary. This is called the 4 generations rule. We can see in the diagram displayed on your screens that starting from F, who is in the first generation, and up till F triple S and F1, FS1 double S are the people within the 4 generations rule. Therefore, all these male holders or the lineal male descendants starting from F are included within the coparcenary. But F double S and F S1 triple S are in the 5th generation from F. Therefore, they are not included in the chain of coparcenary. But if F dies, then they will also come into the 4 generations rule starting from Fs or Fs1. So, we follow the 4 generations rule in coparcenary under the Hindu law. Now let us see the leading case law on the 4 generation rule. Now let's see a leading case law on the 4 generations rule. That is the case of Moro Vishwanath versus Ganesh Vittal, 1873 Bombay High Court. The facts of the case have been represented by way of a diagram shown on your screens. Here, A is the last male holder. He had a son B and B had a son C. C had 2 sons D and D1. D had 2 sons E and F. D1 had a son G. Here what happened was, it was for B who died first, then C died, then D1 died. And A was the last to die here. In this case, G filed a suit against D for a share in the ancestral property. But the court held that G is separated more than 4 degrees away from A. Therefore, he did not form the part of a coparcenary of A. Thus, he is not entitled to a share in the ancestral property. Whereas, on the other side, the sons of E and G, which are within the same generation as G, but are included in the coparcenary, because after the death of A, D was the 4th in the 4 generation rule. He got the ancestral property. Thus, He is now the last male holder. So below him are E and F. Therefore, E and F are now the parts of the co-parcener along with D, but G is not, because G was separated more than 4 degrees away from A. This is the 4th generation rule. By far in the video, we have covered the concept of joint Hindu family and coparcenery. Now let us see the differences between the two. A joint Hindu family is a broader concept, whereas coparcenery is a narrower concept in relation to a joint Hindu family. A joint Hindu family includes dependents like widows, mothers, daughters other than the coparceners, whereas coparcenery is extended only up to the 4 generations in the lineal male descendant as per the classical concept. Now coming to the difference of membership. The membership of a joint Hindu family is acquired by way of birth, adoption and marriage, whereas in the coparcenery the membership is acquired only by way of birth or adoption. The members in the joint Hindu family have rights of maintenance, that is, they can ask for expenses of their education, fooding, clothing, shelter and marriage, whereas the coparceners have unlimited rights, because apart from maintenance they can even ask for a share in the ancestral property, that is, asking for a partition. Now, the illegitimate children in the joint Hindu family also have rights of maintenance. They are recognized there. But under the concept of coparcenery, there is no rights given to an illegitimate children. They are not included within the chain of coparceners. The coparcenery is limited to the 4 generations rule, whereas a joint Hindu family includes people distant from 4 generations too. Now we have come to the last topic of our today's video, that is the concept of survivorship under the Hindu law. The concept of survivorship is unique to the Mitakshara school of law only, because the Dayabhaga school do not follow the concept of survivorship. Under the Mitakshara Coparcenary, interest or share in the joint Hindu family property devolves by way of survivorship. What is survivorship? On death of a coparcener, his interest in the joint Hindu family property is transferred to the remaining coparceners. Because of the concept of survivorship, the property rights of women were not protected in the ancient or classical concept of coparcenery. And also, because of this concept of survivorship, an interest of a coparcener was considered to be a fluctuating interest. When one coparcener would die, the interest of other coparceners would automatically increase. And also, if a new coparcener is added to the coparcenery, their interest would decrease simultaneously. I hope you liked the video. If you have some doubts and questions, drop down in the comment section. We'll be happy to answer you. And do wait, at the end of the video, important questions for pre and mains will be displayed on the screen. Do like and subscribe Legal Bytes.